Okay, thank you. This is Thursday, February. I always want to say September. I don't know why, but it is February 24th. And we are going to first, this is Senate Government Operations. And my apologies too. I see a whole bunch of ethical people up on the screen. And I'm going to say that we're running a little late, so we're going to first take up 181, which is what we had on the calendar first. You are welcome to stay with us, or you are welcome to just cut yourself off and join us when we get there. I think this might take about about half an hour, but probably not that long. But I just wanted to let you know so that you didn't think we had completely rewritten the bill so that it was completely non-understandable to you from where we were yesterday or the other day. So just letting you know. So you are welcome to do whatever you want to do. We are going to look at 181, which is why we have Gwyn Zakoff with us and Tucker and Gordon. So with that, we have a new draft. It is draft 1.1 at 9:24 this morning of 181. Is that the right one? That's the latest one, right, Tucker? Okay. So what I'm going to ask is that we start walking through that and go through it section by section and point if there are any issues that we do not agree on. Otherwise, I really hope that we've hashed all of these out enough that we are in agreement. So Tucker, can you start going through this with us? Thank you.
Good afternoon, everyone. Tucker Anderson, Office of Legislative Counsel. You should have in front of you draft 1.1 of a strike all amendment to S181. And I will note before starting out that I highlighted all of the sections that have changed from the underlying bill, and that for each of those highlights, they represent the policy decisions and choices that you made over the last couple of weeks of review of this bill. And there is one area where there is still a policy decision to be made by the committee that I will point out in the new section 3 of the bill, formerly section 2, which was a bit of a tricky section. Section 1 of the bill, to bring you all back, these are enumerated regulatory powers of municipalities. And within Subdivision 1, this was in the underlying bill. You amended Subdivision 1 to allow municipalities to set off portions of public highways in the municipality for sidewalks and bicycle paths, and to regulate their installation and use.
Great. Everybody okay with that little change?
Yep.
Okay. Gone.
Moving along to Subdivision 4. This was the amendment related to traffic calming measures previously. This has been amended to instead read to implement traffic calming devices. I also highlighted the existing cross-reference to Title 23. That has to do with an amendment that comes up later in the bill around the setting of speeds. Originally, some of those requirements had been struck in S181 as introduced, but because of testimony saying that municipalities still liked that language in Title 23, I've removed the strike through here so that it's cohesive with what comes later in the bill.
Okay. I don't see any questions. Okay. Next change.
Subdivision 6, this is adding the ability to regulate the location, installation, maintenance, repair, and removal of storm drains. You'll note on lines 5 and 6.
And we did hear from A&R that this would cause this had no impact at all on the waters of the state.
Right.
So are we okay with that?
Yep.
Okay.
Subdivision 13 contains the next change. And to bring you all back, this formerly allowed for the adoption of property maintenance standards that would be applicable to all premises in the town. This has been rewritten based on what the committee requested just last week to instead state that the municipality can establish standards for the maintenance of all premises within the municipality to protect the health and safety of the public or to prevent injury to other properties in the vicinity. So the two changes here are first, reordering and clarification of that opening clause. So this allows the municipality to adopt standards for the maintenance of all premises. And then the second request from the committee was to add a clause at the end stating that these are to protect the health and safety of the public, so a police power, and or to prevent injury to other properties in the vicinity, which was a clause that has come up in the Shelburne Charter and more recently in the Springfield Charter.
And remind me, this has to go through an ordinance procedure.
Correct.
So the voters of the town would vote on it anyway, whatever they came up with.
They would not
I mean, no, they wouldn't. They could disapprove the ordinance.
Correct. 5% of the voters could petition for reconsideration and would have an opportunity to vote at an annual or special meeting to rescind the ordinance.
Tucker,
Yes.
what do we mean? Remind me what we mean by prevent injury to other properties. What kind of injuries are we talking about?
So this committee didn't have as robust of a discussion around this as House Government Operations did when they looked at the Springfield Charter. But injury is not qualified here. So preventing injury could be preventing financial injury to neighboring
Right.
properties.
That's
That's how the
what-
Shelburne Charter is written. Is injury is broad enough to incorporate any type of injury. You'll see
Okay.
when the Springfield Charter comes over that when House Government Operations took a look at that same language that was proposed in the Springfield Charter, they decided to avoid the potential for financial injury to be considered and very specifically stated to prevent physical injury to properties in the vicinity.
Thanks.
But in this case, what we're doing is the town in writing their ordinance would determine what it is that they wanted to prevent. And then if 5% of the voters didn't like that, they could petition to, so, and 5% of the voters is relatively easy to get on any petition. Anyway, around here, everybody signs every petition that comes along, so.
And to bring back something that Gwynn noted last time and that I brought up for House Government Operations when they took a look at this, there's existing powers concerning the abatement of public nuisances within the municipality that would supplement and support this particular power. And that existing authority would extend to properties that legitimately constitute a nuisance to the public. Some sort of nuisance that extends beyond the boundaries of the private property. So this would be an extension or a supplement to that existing authority.
Is everybody okay with this? I know Senator Collmore, you had some issues with it. Allison, are you
Yes.
giving a thumbs up or asking a question? Okay,
I guess I'm okay.
okay. All right. On to the next one, blighted properties.
Subdivision 24 previously read that the particular municipal officers, the building inspector, health officer, or fire marshal, could determine that a building is uninhabitable, blighted, or vacant, and recover all expenses incident to the maintenance of those buildings. This has been shortened so that it is just uninhabitable or blighted. Vacant is no longer used in this subdivision.
Okay,
Okay with that?
yep,
Yes.
Okay. On to the next one. On page
Second.
3.
Section 2 on page 3 is entirely new in text, but not in concept. This was previously a subdivision in 2291. that allowed municipalities to recover damaged and leaking vessels from bodies of water that shared a shoreline with the municipality. That was taken out and it has been replaced by an amendment to 10 VSA section 1420 that governs powers of the Secretary of Natural Resources to retrieve abandoned vessels from bodies of water of the state. So in subdivision C1, the term or municipality has been added to the clause that allows the Secretary of Natural Resources to obtain an order to recover costs incurred by the agency when they are retrieving these vessels from bodies of water. In subdivision D1, again, the municipality is granted coextensive authority. In subdivision D1 sub capital B, the municipality shall have authority that is granted to the secretary in this subdivision D1A and may remove a damaged and leaking vessel from public waters, provided that the municipality reports the presence of the abandoned vessel to the secretary and the municipality reports the presence of the abandoned vessel to the owner of the vessel, if possible. So qualification there. In subdivision capital C, a municipality shall have the authority to issue civil penalties and impound a vessel when exercising the authority granted pursuant to subdivision B of this subdivision D1. And I'll back up for a moment and note that in subdivision C1 governing the civil violations, there's one more location where I needed to add or municipality to ensure that the municipality can recover costs that are incurred through the process of retrieving the vessel. And that would be at the end of subdivision C1. And I've started preparing a version 1.2 of this amendment that already includes that change.
Okay, are we okay with this section with that minor change?
Yep.
Okay. Thank you. Okay.
Section. I'm sorry.
No, I'm
feel like
sorry.
All right. Section 3 of the bill. This is the authority for a municipality to give up their charter specific authority and then to use general authority that has been granted to every municipality in the state. That's the easiest way to state it. And I tried to find the least complicated, least legalese way to say this and to make it clear that you are delegating authority within constitutional bounds. So this has been rewritten to state a municipality may propose to suspend, that's a change, specific authority granted by charter for a period of, and here's the policy choice that you need to make before draft 1.2, X years or year or days or months. You need to determine how long the suspension is allowed to stay in place before you, the General Assembly, take some sort of final action. So I'm going to.
Knowing how fond you are of Romanettes, I thought you were just using a Roman numeral there.
Not in this case. I do like to say Romanette. I feel
I
like
know, I love it.
a fun part of our drafting. All right.
Okay,
So suspend that specific authority for a period of X years and instead use later enacted general municipal authority granted to all Vermont municipalities by the General Assembly. So that's a long clause, but the request from the committee was make this as clear as possible that the municipality is using law, delegated authority granted to every town, city, and incorporated village in the state.
mhm.
Provided that the proposal is approved by the voters at any annual or special meeting warned for that purpose, according to the procedures established in this section. Most of this is the same as the underlying bill. First, that the proposal can be brought by the legislative body or by voter petition. Second, that the proposal is required to identify and contain a reference to the later enacted law that the municipality proposes to use in lieu of the charter provision. This part is new, and it's put forward for your consideration, but the proposal shall further identify whether the municipality requests that the General Assembly repeal the charter provision identified in the proposal. The discussion that came up last time was that the municipalities would vote, suspend their charter provision, and later the General Assembly would come in, do some cleanup, repeal that provision in the charter to make it clear that there isn't conflicting law out there. Here, this is the opportunity for the municipality to definitively say, General Assembly, we've taken this vote to suspend our charter. Please repeal it.
So
That
does that
charter
refer to the X years up there so that we could vote to suspend this in our charter for 5 years and see how it works out? And then in 5 years, we'd have to review it. And that's why we would identify whether the General Assembly should remove it from the charter.
It gives you, the General Assembly, the opportunity to identify whether you should take the action to permanently repeal the provision.
Okay.
It gives communication between the municipality and the General Assembly as to whether this should be permanently repealed.
Okay. So why do we have the number of years up there? I don't quite understand that.
That is because there is a tension between suspension and repeal. And if the suspension is indefinite or potentially of a long enough term, and I have to apologize because there's not a lot of case law for me to use to identify what a repeal would be in this context versus just a suspension. But the X number of years makes sure that this is a suspension that is being delegated, not a repeal power, and that later the General Assembly can use its core constitutional authority to permanently repeal if that's what the municipality wants. And to highlight what the significant difference is here, it preserves the core legislative constitutional authority, but it gives the municipality the opportunity to have an immediately effective suspension of the charter authority. So they can have the vote, the charter authority is immediately suspended upon the approval of the vote. And then there's this period of X years or months, whatever you decide, where the General Assembly has the opportunity to go into the charter, if that's what the municipality has asked for, and permanently repeal, which is something that only the General Assembly can do. But during that period of years, the municipality is no longer bound by that charter specific authority.
Senator Clarkson, did you have a question?
I'm sorry, Tucker. I think I need an illustration. Does an illustration come to mind of, are we talking about the whole charter or are we talking about just specific, we're talking about specific provisions? I know, sorry.
Sorry.
I need an illustration. This is a lot of, I'd love an illustration of how this might play.
Sure. So one example that came up very recently was the grand juror. And the General Assembly was actually pretty proactive with the grand juror. But a few years ago, you all removed the grand juror from the list of required elected municipal officers. But there were somewhere between 15 to 20 charters that still had a charter provision that said, we are going to elect or potentially appoint our grand juror according to these very specific procedures in our town. In order for those municipalities to use the general law that was provided to every other municipality in the state, they had to go back and amend their charter. Although in that specific case, House GovOps actually reached out to every single municipality that had a grand juror and charter and said, would you like us to amend your charter right now?
But I think an example is a town that has in their charter that they're going to have a select board of 5 members. Now, if we give them authority under general law to determine the number of members they want, they might want to decide that they want 7. they would have to go through a charter change, but they could do it this way by saying, we're going to suspend that portion of our charter and we're going to abide by general law.
Got it. And we just have to decide for how long we want.
No. Oh,
Yeah,
yeah.
the
I think that we
extra-
should let VLCT decide what they think is a good number.
Right. Well, obviously consultation. I didn't mean that. I meant
Oh.
that that's what we're deciding here is how many years that suspension is good for before it becomes law.
And one of the things that I'll note here for you all is to also consider how much time you might need to receive the request from the municipality and put together a, repeal review bill. And I'll jump right to that new subsection here. At the end, I added a subsection F and G. F requires the clerk, once the suspension is approved by the voters, to send a copy of the proposal, a certification of the vote, and copies of the warnings and published notices that are required by the section to House and Senate government operations. So you'll get effectively a notice and the results of the vote for the suspension. And then in subsection G, annually, Ledge Council will put together a list for you by November 1st that says, here are all of the suspensions that were approved last year and delivered to your committee, so that you can start every session with a list of the potential repeals that you should review.
But the town will decide whether they want to do that or not. The town could, on the vote, it could say, should we give the General Assembly the right to repeal? And they could say, no, we want it to be effective for 5 years, but we don't want to give the General Assembly the right to a repeal within that period of time.
They wouldn't request that you repeal. You always have the right to repeal.
Oh. Okay. Senator Collmore?
Thank you, Madam Chair. So I'm just curious why the date was chosen. I could see a town voting in a general election. They could call a special meeting on November 8th in any given year, and they'd have to wait a full year and 8 days in order for them to effectively request the repeal, correct?
That's correct. And I will confess that I just chose November 1st because it happened to line up with some of the other lists that we're required to make. But the public records exemption repeal review is a December 1st list that we create. So it could just as easily be December 1st or January 15th or whatever you see fit.
Okay. And I don't have any particular magic date. I just felt if November 1st goes by and they go, oh, shoot, we missed it. Now we got to wait a whole year.
The other thing to keep in mind is if an individual senator rather than a committee wanted to sponsor the potential municipal power repeal bill, that the deadline in the second year of the biennium for the Senate is the first week of November, from what I remember.
Okay. Maybe it's not that.
December.
Senator Clarkson?
To that point, I would suggest then the date of November 15th. It gives the general election opportunity to happen. It gives the Public Records Office, and it gives us an opportunity to maybe get that information to the public records, to the archivist for review, and gives us 2 weeks to ask for a drafting request if needed. So it puts it right in the middle.
Why do we want it? Why are we requiring this one to be on an Australian ballot? I'm for taking out everywhere where we require an Australian ballot, because many towns do all their business except their election of officers or maybe their budget on the floor.
it's not near town meeting time. November 15th is kind of not, I mean, they have,
They can have this vote at any time. They could have the
Right.
vote in June. They don't have to have the
okay.
vote. They could
Right.
have it at a special meeting. They could have it at a regular select board meeting. That's, so I just want to know why, oh, thank you. Oh,
The,
some
all
huckleberry
of
tea.
these, all of these sections in the underlying bill were drafted to mirror existing procedures in Title 17. And for example, for the appointment, the switch from elected to appointed officers, that's required to be Australian ballot. For charter amendments, that's required to be Australian ballot voting. So in each instance where you were taking a similar power and adjusting it within this bill, it just mirrored the existing authority. So here, this mirrors the charter amendment procedure.
Okay, I just, I guess
But that makes sense then. That's consistent.
except that this isn't, okay. I'm okay with it. I just hate requiring towns to do anything by Australian ballot. Allow them to choose whether they should do it by Australian ballot. And this is a little bit different than creating we have towns out there that created a charter only so that they could appoint their auditor, I think it was. I mean, so now if they decide that they want to go with general law, do they have to create an Australian ballot to change that and go with general law when they don't do anything else by Australian ballot in their town? They do everything on the floor. So anyway, I'm not going to belabor it, but I oppose any time we tell them that they have to do something by Australian ballot.
Hearing that, this, of course, is a policy decision that you all can and should make. So if you want me to remove that subsection, let me know, because I have draft 1.2 open and I can put that change into the next iteration of this immediately.
I'm only one member of the committee.
Yeah, and I don't
Senator-
have strong feelings one way or the other. I don't know whether VLCT does.
Hello, committee. Gwen Zaka from League of Cities and Towns. Thanks for having me speak to this. It'll be really interesting to see what towns utilize this, because this is a lot of hoops to jump through to go back to just general law that every other town or city could go to. It just seems like a lot of aggravation and a lot of work when you're really already 90% there for what you would need for a charter amendment in and of itself. And then there's the questioning of whether or not that's going to stick unless the legislature doesn't act within X amount of time. So I think, that's my first, reaction to this. There's just a lot of hoops to jump through. With regard to Australian ballot, absolutely strike it. I don't think it makes a bit of difference. If the community is used to voting one way or the other, I think that it used what's the custom and practice of that community. In the interest of moving this forward, we'll take it as is. I think the proof will be in the pudding to see what communities actually utilize this rather than a charter process. I just would, again, pointing out that we're asking for a lot of hoops to jump through just to go back to revert to law that every other community is already allowed to do. This is not new authority. This is just going back to general law.
Okay, I side with the chair then.
Senator Clarkson?
Well, this prompts me to ask the LCT what they would do to simplify this.
Well,
Well, I mean, again, I think we have a bit of a disagreement about what is constitutional or is constitutional or not with legislative council in general. So we'll defer to your legislative council on what is constitutional. So if there is this notice and the requirement that there will be a specific year or month timeline in order to have, affirmative, action, I guess you could say, by the legislature to approve or to act on an amendment, we'll take it. I just think that all the steps that go along with it, the more you can minimize the amount of steps. If the voters vote it, the voters want it, they have hearings to that matter. I would think just letting the legislature know that that was what they're doing, then the legislature could do or not do what they need to update that charter. You know, I just don't know why it has to be so drawn out, I guess.
So I'm going to make a suggestion to that, because I agree with Gwen, and I'm sorry, I would completely cross off on line 7 for a period of X years. And then I would cross off lines 15, 16, and 17, or the end of 15 and 16 and 17. And they have to have 2 public meetings. Is that the way an ordinance is passed? Do they have to have 2 public hearings for an ordinance?
I believe so. I have to
Okay.
look. I
Okay,
have to
so
look
I'm
at it.
okay. I'm okay leaving that. Then I would cross off line 4 on page 6. And everything after line 5. And just on the top on line 3, add that the House and Senate Government Operations Committees shall be notified of the change.
Well,
Yes.
so Tucker had referenced the archivist and state records on recording the change. I mean, it isn't.
No,
Isn't that a
No.
piece?
No, he didn't reference them. You
He
did.
I'm sorry. I heard him. You said that was the date. December 1st is when they do that, and they need this to make changes in the public record. Wasn't that the assumption? I assume that was why you were mentioning it.
I was drawing a comparison to
Ah.
what Ledge Council does specifically. It's not the state archivist, it's me, fortunately or unfortunately, that prepares a list of all the Public Records Act exemptions that exist, and a separate list for any that were passed after the year 2019, which come up for a 5-year repeal review. Removing the X period of years, if that's how the committee wants to move forward, again, I can't advise you on what the specific constitutional boundaries would be. I can tell you that in other delegated suspension powers, they are contingent on something happening. There's
Right.
a triggering event. That event is not indefinite. You just went through a period where specific suspension powers came into play, the emergency powers of the governor. But
Right.
those were contingent on a declared state of emergency. They were contingent on events happening. You don't have a contingency here. It's just a delegated authority to suspend the law. So the question is, at what point does the authority to suspend a particular piece of state law become a repeal? I can't
Yeah.
advise you on that, but my recommendation would be to put some boundary around this so that you're not delegating a repeal power. And to the comments that there might be different interpretations of the Vermont Constitution, the Constitution of many other states, and the United States Constitution, the United States Supreme Court, that says that the core legislative powers cannot be delegated, and that no other governmental form, including subordinate units of government, get to sit in your seats and make your decisions for you. I would appreciate an opportunity to review those legal arguments so that I can be corrected. However, I'm very confident that delegating the power to enact and repeal laws to any other branch of government or any municipality is not constitutional.
Thank you, Tucker. That's helpful. So I would propose, Madam Chair, that we do consider a certain number of years. I would keep that in, and but there doesn't have to be an action. It just then goes into law, but there's an action of moving from just living in a suspended land to being an actual change of statute for that municipality, right? mean, it moves from sort of this suspended state to being enacted. Right?
Well, it still isn't real until the legislature
Acts on.
repeals it. So I guess I am a little confused by that because I thought we're delegating the authority right here. We're delegating authority in all of these instances to put up bicycle paths and bumps on the roads, and we're delegating that authority to them. So I don't understand why we can't delegate this authority.
You are delegating it very specifically. You're
Yeah.
giving authority, you're putting the words in of the authority that you are giving, you are granting. The municipalities here are not self-aggrandizing and going into their charters or into
Right.
general law and giving themselves the power. That's an enormous distinction to make, that you
Right.
are choosing the words that go into state law that govern the municipalities. That is the constitutional distinction. And here, I will back up. This is a real power, right? It's being delegated, suspension. So
Yeah.
it goes into effect upon the municipal vote. The charter provision is suspended. The municipality starts using general law immediately. The question that this is attempting to address is, when does the General Assembly step in, and when does this become a permanent removal of that charter authority?
Right.
And the answer constitutionally is that when the General Assembly repeals the state law, right? The charter provision. And the highlighted portion there that I have set up for you all is, how long does the suspension stay in place? And when does the General Assembly come in to take action and say, great vote, great work, you've enjoyed this period without being bound by this charter provision, we're going to remove it permanently, and you strike through.
Okay.
I'm comfortable.
It just seems like it is a lot to go through. Why would anybody go through this when they could just go through a charter change? That this is almost a charter change. And so we aren't really giving them any authority at all, except that we're telling them that they can change their charter and go through the charter
It
change.
just seems to me that, and again, we won't see eye to eye on this issue, is that if there's some statutory language that says the legislature is allowing communities who have charter provisions that conflict with later enacted general law, will be able to revert back to general law. So even if, the appendix of Title 24 and all those charters are considered law, I think that a later enacted law would trump those laws. So I just don't understand why there has to be that next affirmative step. And that's, again, I think Tucker and I just disagree on that. I think he's taking a very conservative view on this. And he's certainly, again, we'll take what we can get, and it'll just, I think that, again, the proof will be in the pudding if communities actually use it.
Well, that's his job, is to protect.
Sure. Yeah, no, I get it. I
Right.
get it.
No, we get,
I get it. Now, I would suggest maybe then 3 years.
I would suggest 10 or 15. Let them have.
Oh,
let
but
them
then
know that.
I think we're thinking this along the same lines, but I'm thinking let them get to it earlier. And you're thinking live with it longer before we act on it?
No, we can act on it anytime we jolly well please, according to Tucker. We could act on it the next week after they do it if we're in session.
Oh, okay. I'm sorry. I thought that they didn't let us know. They let us know immediately then upon the vote.
Yeah, Tucker?
Okay. Yep, I see that. It's in F.
I don't want some of the what I view as some of the constitutional concerns to be mixed with some of the other provisions that come later, some of the elections procedures that are baked into this section. And I don't want it to appear antagonistic. So I'm going to take a step back.
You're not.
And highlight first the suspension powers being delegated. Municipality votes, They live in a world where the charter provision no longer binds them and they're using general law. For how long is up to you all. You just had a discussion about that. The election procedures around this, I would have to look into it. You could remove all of the specific requirements here around hearings and notices. The question would then be under general law and Title 17 for an annual or special meeting of the voters to vote. What are the different requirements under general law to hold the townwide vote that are different from this? How is this more strenuous? And you could amend this section to make it less difficult and less arduous for the municipality based on that, notwithstanding Title 17 requirements. By removing some of the certification language and the Australian ballot language, again, you make it easier for this to happen. And essentially what this section could be boiled down to is a vote to suspend, suspension goes in place, you receive notice, and at some point in the future, within a specific period of time, you go in to either repeal permanently the charter provision or not. And at the end of the suspension period, it goes back in, but there's nothing here preventing the municipality from holding another vote to suspend for an additional period of years.
Right, yeah, okay, so I would go along with Senator Clarkson's 3 years then and say, within that period of time, the General Assembly has to act one way or the other. And just, there's a notification, it uses the same as notification system as for an annual meeting. And 3 years, and they notify, and I do think that you can take out lines 16 and 17 on page 5, and then they notify immediately with the votes and all that kind of stuff, what the vote was, and within that 3-year period of time, the General Assembly has got to act one way or the other.
Right. But Madam
Okay.
Chair,
Yeah,
I'd make sure we keep as much scrutiny as an ordinance change. So I'd keep the public meetings and stuff.
well, if you use the same as for public, for annual meeting, everything else happens at an annual meeting. I mean, that's,
Right. But if you're going to have an ordinance, if this doesn't happen at annual meeting, if it happens at another point, even an ordinance requires scrutiny. So, and public opportunity to weigh in. So it strikes me we still want to keep that.
okay, let's use the same as for ordinances instead of annual meeting. But you know, the way an ordinance happens is that they pass it and then it is there unless 5% of the population asks to have it repealed. That's the way the ordinance works.
Versus the annual meeting.
Annual
notice.
meeting, they notice it, they have to send it out 20 some days beforehand. It has to be on the agenda. They have to have an information meeting and it has to pass. But it's up to the committee.
Is there, as long as there's an opportunity for public discussion of it, I'm fine. What do other
Okay.
people think? Anthony and Brian, you got any thoughts?
No, I like 3 years, and I would just streamline it as much as possible while still allowing, as you correctly point out, Senator Clarkson, some public input on it.
And I just feel like, what we're doing here is we're allowing towns to change their charters. And they already can do that. So I'm agnostic about the whole thing. If you
But we're
folks think
allowing-
I'm
We're
sorry,
allowing them to change to go back to general law, not
right,
normally when they make a charter change, it's to do something that is not allowed by general law. That's why they have a charter.
Right. They can't just
Right.
do whatever they want. It has to be in response to something else we've done.
If they say Barry, for example, in their charter wanted to be able to change the speed limit. If we had had this in place and further on, we allow them to go down to 15. They wouldn't have had to make a charter change. They would have just been able to say, we're going to suspend that part of our charter and go down and use the general law and go down to 15.
But they'd still have to pass an ordinance, right? The legislative body would have to call for.
Well, it's not an ordinance, it's changing the charter. It's adopting a repeal, a suspension of the charter, that provision. And they'd have to have public hearings, yes.
Yeah. Okay.
Okay, can we move on? I did not think this was going to, we are way behind our time.
We
Yeah.
are. And we are
So-
only on page 6.
I know. Are there other places here where there were issues or? Okay, section 4.
Section 4, this is the section of the bill that would allow non-residents to be elected or appointed to town offices. The changes that the committee requested, and I apologize that I apparently did not highlight this for you, is that this now states that a municipality may propose to allow non-residents to be elected or appointed town officers, except for members of the legislative body of the municipality. That was the first request from the last time you visited this, that the legislative body shall be strictly residents. Here's the next change. For all of the municipalities, boards, commissions, and other public bodies, the majority of the members of the municipal bodies shall be residents of the municipality. So for all of those boards, it's going to be a majority residents.
Fine by me.
And again, take out voting by Australian ballot. Thank you.
Yep.
Got it.
Oh, constable.
Section 5, this was the constable piece, and the request from the committee last time was to remove the references to qualified law enforcement officers. So this now states that if the town votes to eliminate the office of constable, the select board shall appoint a town officer, any town officer, to discharge the constable's duties, if any, subject to 24 VSA 1936A. By the way, that's the statute that allows a municipality to remove all law enforcement duties of a constable if that's how the municipality wants to move forward.
Yep.
Town
And I
officers.
would again take out the Australian ballot.
Okay, D1, no more Australian ballot.
In fact, if it were up to me, I would just prohibit them in general, but you know that.
Honey, the horse has left the barn on that baby.
I know. So are we on section 6? I think that was the only change on,
That is correct. And in section 6, this was the section dealing with the recall of local officials. The only highlight there is on line 13. You increased the threshold petition percentage from 15% to 25.
Yep.
All right.
okay.
The next change is actually a removal, and that was in subsection F1 of, and this is in section 8, by the way, the amendment to the appropriate municipal panels statute. You removed the requirement that the decision to increase or modify the number of members be ratified by a vote of the voters by Australian ballot. So Australian ballot has been removed from that subdivision 1. The next change is in section 10, page 12, line 16 is where that section starts. This was the piece on the setting of local speed limits. Formerly, subdivision A was struck in its entirety. It has been put back in. And instead, the only amendment here is that the municipality in that subdivision capital B can set a speed limit that is not less than 15 miles per hour. And again, all of that struck language makes it so you have a dynamic where the municipality, without a traffic and engineering study, can set a speed limit between 50 and 35. And with an engineering or traffic study can set it down to 15 miles per hour.
I totally have lost you.
We're on
Page
page
13.
13.
Oh, so we cruised by local option. Okay, taxes. Okay, page
Well,
13.
because we
Right.
didn't make any changes.
Got it. So okay, thank you. Got caught up. Yeah, thanks. I was trying.
Okay. Section
next-
11.
The next change is in section 11. This was the overly complicated language around vacancies due to absences by select board members. The language has been changed so that the vacancy is only deemed by the legislative body and it is discretionary. So now if a member fails to attend the requisite number of meetings in a year, the legislative body may deem the member's office vacant. And the following sentence now states that the legislative body shall afford the member the opportunity to demonstrate that the absences were due to a reason that is included in the policy. Previously, if you recall, it said that they had to have a meeting to invite the member to disclose the reasons for the absences. And there was concerns around convening a meeting of the board under the open meeting law to hear why someone had missed so many meetings.
Yep,
This is good.
very well done.
Well, credit to Gwen for highlighting how it could be simplified. Section 13 is the next change. Previously, the concept here was baked into the municipal building code statute in Title 24. And this has been moved based on a suggestion from the LCT to the zoning and bylaw section of Title 24. And to bring you all back, this would require, prior to the issuance of a building here, a zoning construction permit, that all other municipal permits that are required for the construction of that particular structure must be issued prior to that final go ahead and build it permit from the town. So this would amend 4414 to add a new subsection B to state that a municipality may adopt a bylaw that prohibits the initiation of construction under a zoning permit unless and until all required municipal permits have been issued, or under Subdivision 2, a bylaw that establishes an application process for a zoning or subdivision permit under which an applicant may submit a permit application for municipal review, and the municipality may condition the issuance of a final permit upon the issuance of all other required municipal permits. This is the exact language that is contained in the wastewater authority in this section right now in Subdivision 12. Gwen, correct me if 12 is not the right number, but it's the wastewater subdivision in 4414. So this is taking that existing structure under wastewater and applying it to all permits that the municipality issues.
Thank you. Are we okay with that?
Yep.
Yep.
And if I am not mistaken, the other 8 pages are all from our off-the-shelf bills. I do not believe we have to go through them again. We have been through them probably 15 times.
Agreed.
Okay. So with those changes, Tucker, what I'm going to suggest here, I'm trying to juggle this afternoon here, is that we go at 3 o'clock to our next topic, which is the ethics bill. At 3:45, we will do the Barry charter change. Or 3:35 or 4, we'll do the Barry charter change. And would you have these changes ready for us by 4:30? Is there any way? I know you're already working on it.
Yes, I can get it ready for 4:30.
So then we could vote this out at 4:30.
Okay.
Is that okay with everybody?
Yep.
because we shouldn't have to have much discussion at 4:30. We'll just, the only real language change that we want to review is the one around the charters. But I think that we're pretty well set on that. Is that okay, committee?
Yep.
Okay.
Good.
Okay. Thank you, Tucker. And just so that everybody knows, I don't think that the difference here between our Ledge Council and VLCT, and it isn't, I didn't see it as confrontational or anything else. It was just I think that was the word you used.
I've
Tucker.
got nothing but love for Tucker, nothing but love.
Yes. And I think that it is just differences, and that those are policy decisions, and we need to hear from all of you. So thank you. I just wanted to make it clear that to anybody who is watching that
It's
this is the sausage making that people talk about.
right. It's creative tension.
Good word. Yes. Okay. Thank you very much, Tucker. Thanks, Gwen. Now, should we go on to our next topic, which has no controversy or creative tension at all? And I'm going to suggest that we didn't even get started until 2:00, so we don't really need to take a break. And if somebody just needs to pop out and take a break, I would suggest we just individually pop out for 2 minutes. Does that make sense?
Yes.
Okay. Okay, thank you. Okay. So here we are with Ameren. Thank you, Ameren. And there is, everybody should have it, a draft 2.2 as of 1:10 p.m. I thought it said 1:10 a.m. and I was going to have to scold you, Ameren.
I think it's posted on our committee webpage too.
Yes, it is draft 2.2 at 1:10 p.m. So, do you want to walk us through that? And what I'd like to do is do the same thing, is look at the sections, and if we're okay with the sections, just, we're never going to talk about them again. We don't want to keep hashing through. So, okay?
Yep.
Okay, thank you.
Okay, for the record, Ameren Abergele Legislative Council. I'm looking at draft number 2.2 of S171, dated February 23rd, 2022. So I
don't think you need to, some of them I think we've already agreed on, like all the things on pages 1, 2, 3. I think we've already talked about those ad nauseum and have checked them off as agreeing to. Does everybody agree with that? They're only the things that we talked about the other day.
Yes.
Correct.
Please.
Okay, great.
Okay.
Thanks.
So the first change that was made from the committee's discussion yesterday, so I am scrolling and scrolling down onto, let's see, this is page 4 under section 1202. And you'll see that there is a slight change here. The language reads, the code of ethics established by this section does not prohibit branches of state government agencies or departments from adopting additional provisions regarding the ethical conduct. Oops, I'm sorry. I'm reading off the wrong section here. I had highlighted the wrong copy with the remainder of the changes. So 1 moment, please.
While you're finding that, the one thing I am going to suggest is that Paul Gillies yesterday suggested that we put in an intent or in an introduction, and I don't know if we need to have that in here or if we put it in the introduction to the actual code of ethics. But I think that was a really good suggestion, quoting Article 6.
Agreed.
Okay, now that I'm on the correct version, This section does not prohibit branches of state government, agencies, or departments from adopting additional provisions regarding ethical conduct not covered by this code of ethics. And that was a clarification about any additional ethical conduct type provisions that branches or agencies or departments want to have on their own, to the extent that this code of ethics does not cover everything regarding ethical conduct. And then the next change.
Are we okay with that, everybody? Can we?
Yes.
Yes.
Terry?
I guess I'm not, only because that would mean the code of ethics does not prohibit branches from adopting provisions regarding ethical conduct not covered by this code of ethics. So would it prohibit provisions regarding ethical conduct covered by this code of ethics? And if that's the case, then I think we have issues.
Yeah.
Well, the next phrase is that you could have provisions that are covered by this code of ethics, but they would need to, in a sense, exceed or be more stringent than what is in here.
Yeah, but we've talked about the fact that there are provisions in the professional rules of conduct that are less stringent, but they need to still be honored.
What would be less stringent?
I think the appearance of conflict was an example. Mike Kennedy would be the best person to address because he knows the rules inside and out, but I know examples were given. And it wasn't just those that exceed.
Before we get too far down this road, let me go through the remainder of the changes to see
Okay.
if the other changes address your concerns in that respect.
Great,
Okay,
thank you.
great.
So next, moving down into section 1203, conflict of interest, appearance of conflict of interest. You'll see there is a new subdivision 2 under subsection A, except as otherwise provided in subsections B and C. When confronted with a conflict of interest, a public servant shall recuse themselves from the matter and not take further action. So now we will go down into subsection B on page 6, and 1, 2, and 3 are all new language, and there's also a change in subdivision 4. So legislative branch, subdivision 1 now reads, a member of the General Assembly shall comply with legislative branch rules and policies regarding the course of action a public servant may take when confronted with a conflict of interest or the appearance of a conflict of interest that is related to core legislative functions or duties. 2, judicial branch, a judicial officer shall comply with the Vermont rules of judicial conduct regarding the course of action, that should say a judicial officer may take when confronted with a conflict of interest or the appearance of a conflict of interest that falls under the rules of judicial conduct. 3, government attorneys, a public servant who is a licensed practicing attorney shall comply with the Vermont rules of professional conduct regarding the course of action the attorney may take when confronted with a conflict of interest or the appearance of a conflict of interest that falls under the Vermont rules of professional conduct. And then lastly, the change in subdivision 4 is that in the first sentence, it now reads, any public servant facing a conflict of interest not covered by subdivisions B1 to 3. Previously, it said any public servant who is covered by subdivisions 1 through 3. Now this is changed so that it's situation specific rather than person or type of person specific. So, yes.
Yeah.
It's just a simple question. Can you remind me who judicial officers are? Because they're not the judges. Are they the judges? Christina?
Yeah, judges, hearing officers, magistrates, assistant judges, and I think there's one more, but yeah, it includes judges. It's defined by the judiciary and their code of conduct. So judges, magistrates, hearing officers, assistant judges, and maybe if Scott's there, he can help me out with the last one.
Might be judicial master. I'm looking at it now, but that's my understanding as well, Senator Polina, that it refers to what we know as judges.
Because I thought judges were exempt from all this to begin with.
They were originally, and then the version from last Friday removed
Okay,
that.
now I remember. Thank you. Sorry about that.
I think that the difference is that they're covered when they're acting as a judge, they're
Right.
covered under those rules. When they're not acting within their judicial role that is assigned to them as a judge, then they are covered under this,
Got it.
under the code of ethics. The same thing for the attorneys and
Right.
the legislators.
Right. Thanks.
So Terry, does that help you out?
No, I don't think it addresses my question about the wording under the original version, because it still talks about prohibited, it may be prohibitive to have rules that are not covered. So that would imply that if it is covered, it is prohibited. I mean, it's just a wording, I guess.
Where are you that you're referring to?
The one that was most recently added in the 1 o'clock change on page 4, it says that the Code of Ethics does not prohibit branches from adopting provisions regarding ethical conduct not covered by this Code of Ethics. So the logical following would be that it does not prohibit additional provisions regarding ethical conduct covered by the Code of Ethics.
Oh, we can fix that. I don't think that was the intent at all.
I would hope not, because it wouldn't make sense,
No.
but I just wanted to point out that that's what it literally means. So
I think it can say instead, from adopting additional provisions regarding ethical conduct that is covered under a professional code of conduct, or whatever we want to say.
yeah, but it would need to be reworded, because as it's stated now, I don't think.
I know that's what I just thought I said that.
Yeah, no, I agree. But so when you said, does it address it? I was saying, no, it doesn't. The additional changes, the changes on page 6, you were asking, did that cover it? And I was saying, no, it didn't. But what you're suggesting now, I think does.
Okay. Christina?
Yeah, I think this just goes back to the fundamental principle that you can adopt unique provisions that don't conflict with the Code of Ethics, or you can create higher standards, but you couldn't come in with a policy that directly conflicts with the Code of Ethics that's a lower standard. So that's what that language is trying to get at.
Okay, well then that brings up an additional question, because yesterday when we were talking about what rules control if there is a conflict or if there is inconsistency, and I thought that you had said, well, the occasions are rare, but when that does happen, the rules of conduct would control versus the Code of Ethics.
Right. And I think that's what the language that Amarin was speaking about speaks to. So when it's a situation that only an attorney would have faced and it's covered by the rules of professional conduct, then you follow the procedures that are in place under the rules of professional conduct.
Right, but you didn't include that language that we suggested that makes it very clear that when there is an inconsistency, the rules of conduct control. That's not stated.
So I guess if I'm understanding you, say when both the rules of professional conduct and the Code of Ethics would address a situation, you want it to be clear that for attorneys, they should follow the rules of professional conduct. Okay.
Right. Okay, thanks.
Madam Chair,
Yes, Vince?
if I recall correctly, it was around 1989 that the appearance of conflict was struck from the rules of professional conduct. I'm thinking back, I'm just from independent memory, and I see that includes under government attorneys appearance of conflict of interest on line 14. Has that been considered by the committee specifically?
I don't know. First of all, I don't know why on earth you would have eliminated the appearance of conflict of interest, just as an observation. But I think that what we're trying to say here is that if an attorney is acting as an attorney or a judge is acting as a judge, they are covered by their rules of professional conduct, or the judicial rule, whatever that's called.
Right.
When they're not acting as an attorney, but they're acting as a state employee in their position, they are covered under the code of ethics. If there's a conflict ever, and there shouldn't be a conflict because they're acting in two separate roles here. The attorney, I don't know that the attorney rules of professional conduct covers your administrative role. Do you, if you hire somebody, or if you write the budget, is that, or you give a contract to somebody, that isn't really your role as an attorney or as a judge. That's your administrative role outside as a state employee. It might be your role in that position, but it isn't your role. You don't have to be an attorney to be doing that.
No, I understand that, but I think if that's going to be the position of the committee, it should be written into the language that says that. So someone
I
picking
think
this up
that's what it
intended
says,
well, okay.
but maybe not.
I
Scott?
respectfully disagree with that.
Okay. Scott?
Yeah, thank you, Senator. Scott Griffith, interim state court administrator with the Judiciary. The language that was in Terry's memo yesterday, which made reference to lawyers, and which we talked about yesterday, if it's going to apply to lawyers, it ought to apply to judges, may be a way to clarify, just to make it very clear where there is a conflict, the Code of Judicial Conduct or the Rules of Professional Responsibility will apply. And this is for Christina and TJ. I understand that the design is such that the conflicts that will arise, Christina, yesterday you were saying is 0.1%. And while that may be true, it may not be true. The Code of Judicial Conduct, for example, provides for what a judge should do when faced with a conflict in situations that arise off the bench. For example, when a judge is participating in educational, religious, charitable, fraternal, or civic organizations and activities. So that's pretty broad. And so I just want the committee to be aware that the Code of Judicial Conduct does contemplate that a judge acting off the bench might be faced with a situation in which the judge has to react because of the conflict. And if it's the case that there is a conflict between what's required by the code and what's required by the Code of Judicial Conduct, that is, and what's included in the Code of Ethics, we would just ask that the committee consider making it clear that the Code of Judicial Conduct is what should guide the judge, because otherwise the judge could find herself or himself in violation of the state Code of Ethics, subject to a disciplinary scheme that's outside of the branch, as opposed to what was intended by the court in adopting the Code of Conduct.
And Madam Chair, I would say that ditto for the other two categories, legislative and attorneys.
And Madam Chair,
if there's a conflict, the code for that particular profession would govern the conduct and whether there was a violation.
Well, then in effect, they're exempt. They're totally exempt then from the state Code of Ethics. All the judges, the attorneys, and the legislators are now totally exempt.
No, only if there's a conflict. If there's a conflict between the state code and their judicial, legal, or legislative, it would only be in those narrow situations.
Okay, got it. Yep. Scott?
Oh, no, sorry. I forgot to lower my hand. I'm sorry.
That's okay.
Madam Chair, this is John Campbell.
Hi, John.
I apologize, but I don't know how to raise my hand here. I'm still trying to figure that out. I pushed
You
every
just
button.
wave, but we can't see you either, so we can't tell if you're waving either.
Sorry. Yeah,
That's okay.
thing closed there. Okay. I just want to echo, I agree with what was just said, but there's also another issue, like if you take, and why I think it's important to really make it clear is if you look at my position, clearly I'm an attorney, but I'm also the director and I have a bunch of other obligations. Now, I consider myself always to be under to come under the Code of Professional Responsibility in any action that I do. But in this one, the question is, So what am I covered under is the executive director. And is it my professional code of or the code of ethics or the professional conduct rules? So I think that's why there's I believe Terry had provided language yesterday, which I thought covered everything, but I guess you all decided not to go with that.
And to echo that, Madam Chair, if the language were to say that the state code of ethics would apply when the appointed, elected, or state employee is performing, a non-judicial duty, if that can be parsed out, then at least the discussion, the intent of the committee would be reflected in the language, and somebody picking this up in Bennington or Brattleboro or Swanton or Canaan would be able to glean legislative intent from the words of the statute.
Yeah. Yes.
Christina?
Yeah, I think, I'm not sure if John was participating in the conversation yesterday, but I think the fundamental question was, which one are you covered by? Well, you're covered by both. And so it depends on the action you're taking. So we're talking about the difference between, an attorney-client relationship versus, your role as a supervisor. So if you're an attorney, but you are acting as a supervisor and you're questioning whether you should be supervising, your stepdaughter, then that's clearly going to fall under the code of ethics, because that's not something that the rules of professional conduct would cover. When you're talking about attorney-client relationship, then that's something that clearly the rules of professional conduct are going to cover. And so the situations where you are potentially where there's potentially an overlap, say you are a public defender and you've been assigned to defend your roommate. So clearly in those cases, that would be a narrow situation where both would apply. And so we're perfectly fine with saying, like, okay, either way, you're going to recuse yourself. So if there's language saying like you should follow the rules of professional conduct in that situation, then that's fine. But those are the very narrow set of circumstances where those are genuinely going to overlap. And the rest of the time, it's going to be pretty clear that both apply to you. But depending on the role that you are playing, that's when you're going to look, to the code of ethics versus the rules of professional conduct.
So Madam Chair, on that specific example, there is an exception in the rules of professional conduct that do allow exceptions for immediate family members. I don't have the language in front of me. Maybe Terry knows it better than I do, but I know there is an exception in that very situation. Maybe John knows it. I just don't remember it off the top of my head. I know enough to know that somebody has to look.
Yeah, Vince is right on that, but the other thing too is that you're taking, Christina, you speak all the time about just the attorney-client privilege. There are other things that obviously our code of professional conduct cover, and it's not just because of the role. It doesn't have to be that I am actively representing a client.
Right.
So it's a very broad scenarios that are.
Right. It wasn't attorney-client privilege, it was the attorney-client relationship. So I don't think there can be an argument that the rules of professional conduct are really centered around the attorney-client relationship. And so say you have a situation where we're in private practice, now you're working for government, and you come across a situation where you're being asked to prosecute, a company that you previously represented. So in that case, that would actually not come up against the code of ethics. That would be a rules of professional conduct situation, and you would follow those rules. If you're in a situation where, say, you are being asked to sit in a hiring committee and your roommate is one of those candidates and you're attorney. So you're not acting as an attorney in that situation. You're acting as a government employee that has a say in over hiring decisions. So in that case, the code of ethics is going to clearly apply. And so the question is, when those two things overlap and there is a conflict under a conflict of interest, and the question becomes, which procedure do you want to follow? We're perfectly fine with adding some language that makes it clear that when there is an overlap and if the attorney is faced with that question, then follow the rules of professional conduct, because the answer is always going to be pretty clear. You should recuse yourself.
It seems to me that all we need to do is add something in here that says when there is a conflict, that that it is the rules of professional conduct or the judicial rules that apply. It seems to me that if we say that, then if there is a conflict, that's what applies.
Right. If
I
there's
don't
a conflict
understand
between the state ethics code and the specific judicial or rules of professional, that then in those instances, the judicial rules of conduct or the professional rules of conduct apply.
Yeah.
Then at least that would be clear. And then if you would further want to clarify the substance of the conversation we're having this afternoon, and that is that if a person is not acting in a judicial or attorney capacity, then the state code of ethics would apply. But I think the lines there, as John has said, are very gray. It'd be hard to parse out where you were acting as an attorney or were you acting in a non-attorney capacity. If you're an assistant attorney general or a deputy state's attorney, I think the default is going to be you were acting as an attorney. That's what you do for the state of Vermont.
I think we're
Yeah.
getting to a situation where we're talking about basically exempting judges and attorneys all over again. And I felt like we had gotten past that. So the conversation that we had centered on was conflict of interest and the procedures that were to be followed. And from what I've heard in the past discussion, it was basically like, what procedure do you follow in a particular situation? And so the answer to that was pretty clear. If you're covered by the rules of judicial conduct or the rules of professional conduct, then you would follow that procedure. And so to me, where we had arrived would be that would maybe add a couple of words clarifying in each of those sections about judicial officers, attorneys, just saying like when there is a conflict between the two, then, the rules of professional conduct or the judicial rules of conduct shall apply.
Very-
Well, okay.
That was my understanding too, is that we were
Right.
going to cover it and make sure we covered all these concerns, these very focused concerns in those sections above.
And it is around the conflict of interest. You can't tell me at all that any of these other issues like misuse of property or misuse of information or anything, that we should exempt anybody from that. I would not exempt anybody from those. So Terry?
Hi. Actually, in my memo yesterday, number 3, the exact language that we're talking about was suggested, limited to the conflicts of interest scenario. So I think that's, and we had hoped that maybe that's what would be incorporated, but it hasn't been yet.
Yep.
And I did just have a question, Christina, for what was added on page 6 in the government attorney's part, a public servant who is a licensed, practicing attorney. I didn't know what practicing meant or why that was added.
Yeah.
Sure. I mean, I think the situation is so, I'm a licensed attorney, but I've worked on policy issues. So I was not practicing, I was not a practicing attorney, but I was an attorney. So we cover those situations where you may be licensed, but your role is to, say, draft policy memos on a specific issue.
Well, I think it has the effect of limiting.
Yeah.
applicability.
Limiting what?
The applicability of the code of ethics then. To me, it's not a term of art to say a practicing attorney.
Right.
I feel like it confuses the sentence.
So
if you left it as
You have to define what is an active practicing, what is a practicing attorney? I mean, I'm an attorney, I'm a practicing attorney, but yet I'm doing some policy. Is that not practicing? I mean, I'm not out prosecuting a case.
I
But
think
I'm
if your
still
entire job is doing
practicing
policy,
attorney.
then no, I think if you are a practicing attorney and you're involved in litigation, then you're clearly practicing. But if it's going to get us past there, then fine. Just take out the word practicing if you like and just leave it.
Yeah.
yeah, I think that would.
okay, let's
Good.
do that. We're done with that topic. We're done with that. Yes, Ameren?
So I understand I will be removing the word practicing for the next version. Okay. Let me do that right now before I forget.
Well, I think we're done though. If that conflict, if there's a conflict, what controls? I think that still needs to be added.
I
Cameron?
think, yes. So looking at this language, which is why I waited for this conversation today. So previously what I've been hearing from the committee's discussion is that you have two scenarios that most of the time it will be relatively clear whether the conflict is within your role as an attorney working as an attorney in your position. And then there's instances where the conflict is around you being a government employee, in your role as a government employee, as a supervisor or as a colleague. And then you have this, I think what everyone has mostly narrowed in on is that you might have this smaller subsection where there's an instance where this could be a conflict of interest issue, both under the rules of professional conduct as well as the code of ethics. And I think the challenge with the suggested language is that it brings up something that we have not, I won't say we haven't talked about, but I haven't heard a clear decision on so this is saying if there's an inconsistency with the code of ethics and the Vermont rules of professional conduct, the Vermont rules of professional conduct shall control. And I think what my question is, what if the bar under the rules of professional conduct is lower than what we have under the code of ethics? What is the employee to do in that situation? This would say that if it's okay under the Vermont rules of professional conduct, then you can do it, but the code of ethics would say you really shouldn't be. And that is why it is not in this present draft, because I didn't hear that nuance really decided, I would say, from the committee's discussion so far. And I'm not sure, I didn't want to add that without having a bit of confirmation on where everyone stands with that.
So we're talking about lowering the bar for the bar?
I think that what we talked about was that the higher standard would apply.
Yeah, that's what I thought.
I think we were talking about really when it came down to it procedure, right? So the question would be like, okay, you're presented with this conflict of interest. And so you are following the code of ethics conflict of interest. But when it comes to the procedure that you're going to follow, if there's an overlap, then you'd follow the rules of professional conduct. So for example, you are in a situation where you're asked to prosecute a relative. So I think in both cases, the code of ethics and the rules of professional conduct require you to recuse yourself. However, the code of ethics would say you should recuse yourself by telling your supervisor. And if for some reason you want to go forward, then you would file a written statement according to like the judiciary's policies and procedures. However, the rules of professional conduct just tell you to recuse yourself. So in that situation, the answer to me is pretty clear. You're going to recuse yourself. So if you want to follow the rules of professional conduct, then there's really no issue on our end, in terms of like what procedure you're going to follow. So if you want to say when there is that type of conflict, then the procedure that is under the rules of professional conduct apply, then I thought that's where we were.
Yeah, that's why I thought we were too.
And
Yes,
that's my
Karen.
understanding, which would be, technically a lower standard, but it's still the rules of professional conduct that apply.
I don't know if it's a lower standard. I wouldn't say it was a lower standard. I think we're just talking about procedure. I don't not,
Yeah.
definitions or policy. So
Right.
I actually think that the code of ethics would be the lower standard in that case, because it would allow you to proceed if you filed a written statement, where the rules of professional conduct would just tell you to recuse yourself.
Oh,
This is
okay.
about the action that is taken when there is a conflict of interest. This isn't about whether there is a conflict of interest. This is what you do when there is a conflict of interest. And it seems to me that if the rules of professional conduct say are so vague on a particular way that you recuse yourself, if you're giving out contracts to people, I don't think that has anything to do with you being an attorney. You're awarding contracts, and you should be covered under the code of ethics because you are acting as a government employee, and you should be covered under the code of ethics. So I'm confused about why we're having this, because I thought we had said that was where we were.
I thought
Madam
so too.
Chair, I thought the example given by someone was a good one, and that is there is an exception in the rules of conduct that allow I think a judicial officer or an attorney to represent an immediate family member, notwithstanding what would otherwise be a conflict. And I think that comes up in a situation where a deputy state's attorney might have a child who gets in trouble and the child calls the father or mother, and the father or mother gives advice, which you and I would think, hey, that's crazy. But then, of course, as the rules have thought that through, who else would a child call but a father or mother who happens to be in a position? So in that case, they'd be okay within the realm of the rules of professional conduct or the judicial conduct rules, but would be in violation of the state code of ethics. I'm not sure that really should be the legislative intent, and it might play out that way.
I'm not sure that even is a good example, because I don't think that the person is acting either as a state employee or as an attorney. They're acting as dad.
But given legal advice.
Under the code of ethics, you could file a statement saying, yes, like I recognize that this is a conflict of interest under the code of ethics, but I would like to go forward for XYZ reasons, because it's allowed under the rules of professional conduct, because it is my son or daughter. And to me, that justifies my representation of this person. And then you'd be able to go forward under the code of ethics. So there's not actually a conflict there.
So the way that
in this case, the rules of professional conduct, yeah, there's not actually a conflict in that situation.
So Madam Chair, the way that would play out would be you get a call at 2 o'clock in the morning. My son's been arrested for burglary or DUI, and the attorney says, well, wait a minute, I have to write a letter to the State Ethics Commission. I'll get back to you next week. I mean, that and $1 will get you a cup of coffee.
You would never write us a letter. It's always done internally. So you'd only be following the procedures that are in place within the judiciary. You're never writing us a letter. So you can take your action, and then you can go into your office the next day and talk about it with your supervisor, whether you should recuse, whether you should go forward. If you decide you want to go forward, then you can just say, okay, the process would be to file a statement saying, like, I am representing my close relative. This is why. This is allowed under the rules of professional conduct, et cetera, et cetera.
What if he's the supervisor? Let's say it's Vince's situation where Vince is the sole state's attorney in his county.
Mm-hmm. Well, I guess he would call you, I guess, to see what to do. Or maybe,
No.
This is something that the judiciary would be working out for themselves, in the sense that when there's an overlap, we are saying that when there's an overlap, you can follow the rules of professional conduct.
Right.
However, under the code of ethics in these situations, you could also go forward in the sense that you can opt not to recuse yourself. You can say, I think I have a justifiable reason for moving forward with this. This is my son. This is like the normal action that a parent would take. I don't see why there's a conflict with any of my other responsibilities in the situation. And then you can file a statement with the judiciary, as the judiciary has determined a statement should be filed.
Can I just say that I think we're spinning our wheels. I think that what we've decided is that if there is a conflict, it's the rules of professional conduct or the judicial rules that apply. So why is that? I thought that's what we've decided. And yet we're giving examples that say, well, which should we do here? It clearly says, I think, that it's the rules of civil, whatever those things are, that apply if there's a conflict. So I don't understand why we're having this discussion. Maybe somebody can help me out here, but I don't get it.
I think it's just because you're trying to point out the potential for unintended consequences here. When you're dealing with topics like this, subjects like this, we're talking about people's livelihoods, or we're talking about potential reputation ruining things, saying, oh yeah, he's got an ethics complaint. She's got an ethics complaint against her. Those things matter, and especially when you're dealing with the legal profession.
But you can have an ethics complaint right now, and anybody can file an ethics complaint anytime they want, whether whether we have a code of ethics or not. And you have a professional code, and you follow that code. That's the simple answer. If there are things that are not covered by your code, and you're as a public employee, then you follow the code of ethics. If they're not covered by your code.
Exactly. Well, the point, Madam Chair, not to argue it, but is that, again, in my position, I consider myself an attorney, a practicing attorney in the role that I'm doing. Now, that sounds like, Christina may think that's not the case. So, when it's not clear like that, I think you're setting up situations that could be very detrimental to people's livelihoods.
Well,
Anyway,
first of all complaints are confidential. There is no enforcement procedure in this, any of this at all. The only enforcement procedure is from the bar or the judiciary. The Ethics Commission has no enforcement procedures. If they get a complaint, they will give it to, from an attorney, they will give it to the board. They'll give it to Mike Kennedy. That's where it'll go. It doesn't go anywhere else. So the Ethics
that would beg
Commission,
the question. Well, never mind. I'm sorry.
Well, Madam Chair.
we're not going to get into enforcement in this bill at all, period. The Ethics Commission is a funnel for complaints to be distributed to the other branches and the other enforcement.
appropriate, the other appropriate places. Madam Chair, Ben, I
Yes.
think Ben and
I,
Scott.
yes, I do see that. Thank you. Ben,
Thank you, Madam Chair. For the record, Ben Kinsley, Campaign for Vermont. I think, this is sort of the same issue we've been dancing around for several weeks now. And the draft that was brought forward on Friday contemplated a situation, I believe, where the definitions of conflict of interest could vary between a code of professional conduct and the code of ethics, and in terms of how to resolve those conflicts. So the draft from last Friday indicated that if a potential conflict of interest exists, you would follow the rules under the code of professional conduct, or the judicial rules, in order to resolve that conflict. Now, if the judicial rules in a certain situation said you can proceed under this set of conditions, then you would follow those rules, because those are the rules that you would follow to resolve the conflict. So I think that was the approach that was taken with this draft from last Friday, is like, here's a universal definition of conflict of interest, but then to resolve a potential conflict, you can follow a couple different procedures, whether that's the legislative procedure or the judicial procedure or what have you, in order to resolve that. That was, I believe, the approach of the bill from last Friday, as opposed to, and that's fundamentally different than saying, if there's a conflict between the definition of conflict of interest between the conflict of interest definition that's in the code of ethics and the one that's in whatever professional code of conduct, then the professional code of conduct takes precedence, because that does open a door to a possibility where those professional codes of conduct could have a lower standard for what conflict of interest would be. So I think, the difference is there a difference in the definition? Are you changing the definition, or is there a difference in how you resolve the conflict when one presents itself?
thank you, Ben. And I think
That
that
helps
is
me a
what we're
lot.
talking about here, is how you resolve. What procedure you follow to resolve the conflict.
So maybe that helps to direct the conversation. I'm not sure, because there's a couple different ways to think about this.
And I don't mind pointing out that, the judiciary already does have, a code of conduct in place that covers attorneys, and it has its own language around conflict of interest. So this is really not that different from what we're talking about there. If attorneys are already operating under two different codes of conduct, the rules of professional conduct and the judiciary's code of conduct, which covers all employees, then we're talking about a situation that's already happening in reality. And, the rules of professional conduct don't specify what you're supposed to do when you recuse yourself, unless there's some separate procedure that I haven't seen online anywhere. But there is a procedure in place under the judiciary's own, code of conduct that applies to all personnel, which says you have to recuse by telling a supervisor. So there's really very little daylight, if there's any daylight, between what's already happening in practice and then formalizing this code of ethics.
Madam Chair,
Okay,
the judicial
where
rules
are we?
do not apply to attorneys, and the rules of professional conduct do not apply to judges. They have their own code of conduct. They do not overlap.
They
I
do.
don't think she said that. She said that
Okay.
the attorneys are covered, who work for the judiciary are covered also by the judicial rules.
They're covered by the judiciary's code of conduct that that it's found in their personnel manual for policies and procedures. There's a code of conduct. I think it's about 4 or 5 pages, and it specifically covers attorneys.
So attorneys are already covered by 2 different.
Correct.
So. Or we could just completely eliminate the whole judiciary and all attorneys from the code of ethics, and then the judiciary and all the attorneys that work for the state would have to live with the optics of that.
Yeah, I think the optics of that are bad.
Madam Chair, I'm taking no position on that. But I will just say that I think the reason why there is spinning going on is to the point you made a few minutes ago, which is there is vagueness in some of the language. And I think that was by design in the Code of Ethics. There's also, I think it's important for the committee to recognize that it's not just the attorney-client, and I'll defer to others who have more experience than I do on this, but it's not just the attorney-client relationship that is covered or addressed in the rules of professional conduct. There's a breadth to those rules that cover what a licensed attorney might do in Vermont, and that would subject them to being the subject of a complaint. There's a section that deals with misconduct. It's got 6 or 7 provisions. The majority of those have nothing to do with that person's work representing another person. And so I offer that to give the committee and others who are watching, I hope, some comfort that whether the judiciary is exempt or not, there's a breadth to the codes and the rules that apply to judges and lawyers that I think people ought to acknowledge and regard as being effective in being a disciplinary structure that the court has administered for decades. So I just don't want that to get lost in the conversation. And so it's not surprising to me that we are spinning, because there is vagueness in the Code of Ethics in the bill we're looking at, and there's a breadth of behavior and activities that are provided for in the rules of professional conduct and the Code of Judicial Conduct. And so I don't know that it's correct to say that those times when there will be conflict between rules and codes is 0.1%. I don't know what it is. None of us know what it is, but I just ask the committee recognize that there are existing standards and codes that apply to judges and lawyers, which are very broad.
So I would just ask where there is vagueness in here that would confuse judges or attorneys in the language
proposed code
in the bill.
No, I was responding, and that's something I heard you say, that these are vague, and I think you meant it in a way that.
No, I didn't mean anything was vague. I meant that we have some umbrella policies here, and it seems to me that if attorneys and judges cannot abide by the big policy that says you should not misuse the information that you gained as a government employee for personal gain. If judges and attorneys don't want to be subject to that, then there's something the matter. It isn't vague, it's broad.
I misunderstood. It may be the case that they're already covered is part of what I'm saying, because of the breadth of the code and the rules.
Right, but then what is the issue?
The problem? Then what's the problem? If we've referenced that in all the sections above in the conflict of interest, what's the problem?
I guess sorry. Go ahead, Scott. Sorry.
Yeah, the problem, there may not be one, other than there may be a conflict. Right? I mean, that's and I think that's part of what we're trying to resolve is, in the event of a conflict, how do we deal with that?
And if I may add, if we already have like our code of professional responsibility that already tells us how we're supposed to act and what we're supposed to do, what we're not supposed to do, which I can assure you is very vast and it's, again, just not just dealing with attorney-client privilege, then why are we having this exercise? Or we're just saying, so you have to have more rules on top of more rules. I have no problem, and I don't think there's a question, Madam Chair, the scenario that you just put forward. I think that's covered under our rules too. And if we breach those rules, or if we commit some act, then we should be, and rightfully, sent to the Professional Conduct Board, and we face anything from fines to disbarment. So, I mean, I think that's really what we're saying here is that while there's great intentions, and I believe it's great that we're having an ethics policy here. And as you said last week, I was the one who told you when I was pro tem, we need to make sure we have an ethics policy. But to put it covering people that are already covered on something else, I think that's what we're concerned, at least some of us are concerned, that there are going to be conflicts and there could be misunderstandings and the question of who is our master, if you will. You know, is it the courts, or is it the Ethics Commission?
So I'm going to make a comment here, and then I'm going to go to Pat and then Christina. So in that case, we don't need an ethics policy at all, because every licensed professional, every licensed professional that works in the state has some kind of a code of conduct or ethics. If we have barbers working in the corrections facilities, they have a professional code of ethics. Should we exempt them also from a general code of ethics? Because their code of ethics might not say anything about misuse of information. They're cutting somebody's hair and they hear that, and that charge that was against me, that really was right. I did off him. So he learns that because of his role as a barber. Is he covered under a code of ethics for his profession or not? Or are we just talking about attorneys here? They're the only ones that have such a code of ethics that they don't need to be covered. Every other professional we're going to cover.
I think if you have identified problems, which obviously, again, the professional code of ethics has been for the attorneys has been around for a long, long time, and it continues to be updated to find where there are where attorneys can either get in trouble in the fact that their conduct that we want to make sure that does not occur. If that's inclusive in what you're already trying to solve, let's say the conflict of interest, which you do have here. We do have a conflict of interest policy for government employees in the professional rules of conduct. So what I'm saying is, from a policy standpoint and from a legislative standpoint, is it necessary to do that? If you want, you could just republish the professional rules of conduct and call that the ethics and have them adopt the professional rules of conduct. And this is, by the way, this is not coming from the bar. This is my guess my personal feelings on how this is going.
But if why do we need a code of ethics then? And who would it cover? Who is the code of ethics? If we have a code of ethics, who does it cover?
I think you want to have it cover people who are not covered. I mean, first of all, you can cover everybody, but if there are existing rules that are consistent with the ethics rules that you want to adopt, then the professional rules, in my opinion, should be the one that should govern.
That's exactly what we've been saying all along. That is the language in here, and that is what we've been saying. I don't understand. Pat, I'm going to back off here. Pat, you're muted, Pat. Just hit your little button.
Pat, you're muted.
Yes, I'm here. Thank you. Thank you very much. I appreciate your last comments, Madam Chair, because this has been circular conversation. If the code of ethics, which are so basic that if you can't follow them, maybe you should rethink some other occupation. If they get transferred over to the judiciary, and your code of ethics code of conduct takes precedence. I don't understand what the argument is. My comments, and I know Scott's going to have a comment. We're going to talk later over coffee. Vermonters need a place to go to complain about somebody in the judiciary, somebody in the legislature. I know for a fact, and I know Scott disagrees with me, being in personnel in state government and working in state government for 22 years, people are reluctant to go to the judiciary to complain, to go to the state government to complain about John Campbell or whoever. They need a place, and that's what the Ethics Commission provides for them, a nonpartisan level playing field where they can go and see, first of all, if they even have a legitimate ethics complaint. That's the first thing that the commission will tell them. And then the commission will say, I can refer this to the judiciary, refer it to the legislature to give these Vermonters, and maybe it's state employees. I know several state employees over my tenure there that had issues with certain legislators and certain people in the judiciary, and I know they were afraid to say something. But I think if there was an ethics commission that was supported by the state, I think that would lessen the complaint, and people would have a place to go. And if they transfer that complaint to the appropriate entity, and it falls under your code of conduct or the legislative code of conduct, everybody's got a code of conduct, John. We have personnel ethics in state government. You've got the governor's, which we haven't talked about hardly at all, executive office, executive, God, I can't speak anymore. Executive order, thank you. That covers all appointed officials. There's codes all over. This brings it under one umbrella, and it is so basic. It's sort of, the gentleman from Rhode Island said it's pretty basic and actually pretty low key compared to other states. We are one of a handful of states that can't pull off a state ethics code of ethics. How hard can this be? It's not hard. And if you have language, present it.
We did.
Well, then we should review it. Well, that's up to the chair, obviously, but let's move on.
I think that most of the language had been incorporated, or we thought it had been incorporated. What I'm going to do is we have another thing to deal with at 4 and another thing at 4:30. So what I'm going to do is I'm going to say, I'm going to put this on the schedule for the week we come back, Thursday the 10th at 2:30, and we are going to pass something out. I mean, we can go round and round and round and round. And I thought that we had already acknowledged that, yes, the professional code of ethics, whatever that is, or code of conduct, or whatever they are, takes precedence. That is what you follow. And if I would say if government employees, regardless of who they are, can't abide by these 10 pretty simple statements, then, and Vince, your suggestion about that there is an ability to represent, there's an exemption for representing your own family. Now here it says it says you shouldn't. So you follow that code of professional conduct, and you go to your supervisor. This is about how you resolve that conflict, not whether there is a conflict or not. There is a conflict, but it's how you resolve it. That's what this is about. So Christina, and then I'm going to.
Yeah, I'm sorry. I just really hate to see this put off again about discussion of our attorneys. I'd like to just reground this conversation. So again, almost every other state has a code of ethics and no other state exempts attorneys. So there's a lot of conversation going on around things that have clearly not caused problems anywhere else in the country. I went to law school in Hawaii. All state employees in Hawaii, whether you're an attorney or not, are covered by the state code of ethics. If you work for the Department of Justice, you are subject to the Department of Justice's code of ethics. You are subject to the rules of professional responsibility in any state in which you are barred. And if you are litigating in a state where you're not barred, you are also subject to the rules of professional conduct for that state and that state's code of ethics. So you could just right there be subject to a minimum of 4 different codes of ethics, and that's for attorneys. That is how common this is. So I'm not sure really what the problem is. Vermont is not that unique. This is a very simple code of ethics. Attorneys are always covered by them. So just to kind of like be spinning this conversation into like what should be a very simple conversation into a blizzard. I mean, what's happening here is these arguments about attorneys, which shouldn't really even be arguments, are basically killing the potential for the code of ethics to get passed right now. And, I reached out to John Campbell a few days ago and I said, can we have a conversation? No reply. This to me says that it's not really operating in good faith. There's desire just not to have this pass or have this, apply to attorneys. And this is just stalling tactics. And I'm sorry to be that blunt, but we were there yesterday and now suddenly we're rehashing arguments that we've had over and over again.
Right.
And I will say that there has been suggestions that we should exempt the judiciary branch because of the constitutional requirement, but we know that already the legislature has its foot into the judiciary. We confirm judges, we retain judges, we impeach judges. We already have that authority to do that. And even if we exempted the entire judicial branch, it doesn't exempt the attorneys that work in the executive branch. They're
right.
So we could exempt the entire judiciary, and it still wouldn't. It wouldn't exempt any attorneys that work for the for the legislative or. Yes, Senator Clarkson.
Now to go back to Pat's point, this is an umbrella. This is a funnel. This is a portal for the public to come in, complain to the ethics commission. Then it gets diverted to the appropriate body. It's very straightforward. All the attorney and judicial complaints will get sent to the judiciary and to Mike. So to me, this is sort of we are spinning our wheels because we've already allowed for each separate branch to have the complaint diverted to that branch to deal with. So I think always the judiciary is going to be dealing with the complaints of judiciary, of judicial employees. Always the code of professional conduct is going to deal with lawyers. I really just don't see the problem here. We've enabled the existing ethical oversight to continue to exist, and we are creating a portal for the ethics concerns of the people of Vermont.
So I'm going to go to Terry, and then we're going to switch topics here.
Okay. I think this all grew out of Ameren asking, did she have permission to add that one sentence that says when there's an inconsistency between the rules and the code, did she have permission to add that? And I think Christina did say that, yes, that would apply in that small overlapping scenario. I think that's the only thing that was outstanding, and I don't think any of us are disagreeing with the broad umbrella or having attorneys subject to it, with the additional phrases that Christina's added about the rules of conduct. But I think that was all that was outstanding to move on, was Ameren asking, did she have permission to add that? And I think Christina said she did. So in my mind, that's all that's really needed, I think, to move on.
Yes. Yeah.
All right, we'll add that in for the attorneys, and other people will just do the regular code of ethics.
And for judges as well, Senator.
No, not judges.
Is it?
Sorry.
I mean, it's the language that my understanding was, this is the language when we're talking about conflicts of interest and the procedures to be followed. When there's a conflict, when there's an overlap, then you'd follow the rules of judicial conduct, the rules, the the General Assembly's rules or the attorney rules. And so that was the clarification. It was a very narrow clarification
Right,
around procedural issues. Yes.
perfect.
Yes.
Yes, so the line that I would be adding says where the Vermont rules of professional conduct so apply, and there is any inconsistency between the Code of Ethics and the Vermont rules of professional conduct, the Vermont rules of professional conduct shall control.
And I
That's
guess
what
the
we've been
same
doing.
language under judges.
Yep.
And Ameren, on the judicial branch, it's the Code of Judicial Conduct. The version I'm looking at says Rules of Judicial Conduct, Code of Judicial Conduct.
Thank you.
Great.
I have to say,
Well,
this started the debate here when we first got this, and Anthony will probably recognize this. The debate started out was, should the legislature be covered?
Right.
We've completely, we're there.
Yeah.
Yep.
There was never any, and I will say that I'm sorry that this is happening at this point. We've been dealing with this bill since January. And I'm just surprised that no one in January, when we've had this on the calendar almost once a week since January, that we have not had these conversations before. So I just have to express that. So
I apologize for not having been tuned in before. I'm really sorry that's my fault for not having been paying enough attention. So I'm sorry.
It's no one's fault. It's just because everybody is overworked and most
And
are
underpaid.
underpaid. So we understand that. I just am sorry that we're having it now. But
I think we're at a landing place, which is good. We're setting the bar for the bar. The bar for the bar has already been set. We're enabling it to be diverted to that.
okay. And
Good.
I guess, Ameren, I would also ask that you make sure that the language on page 4 reflects what we need, says it the way we needed it to be
Right.
said.
Right.
Sorry, page
4.
4.
It's the, that you can, if you have it doesn't prohibit any department or agency or branch from setting its own guidelines, its own codes. And Terry had some concerns about that language. So I guess, Terry, if you get some language to Ameren, that would be helpful.
Thank you.
Sure. I'll just repeat the language that Senator White offered, but I can email you, Ameren, on that.
Yeah, why
Thank
don't
you.
you do that?
Yeah.
Sure.
Okay. Okay, thank you.
Oh, so I'm sorry, Senator White, one last thing. I'm wondering if
Yeah.
the committee we talked about it briefly yesterday, but if the committee would consider adding the judiciary to the list of approved education providers. It's something we're already doing, and
I think we already suggested that.
okay.
And I think though that, yeah.
Okay.
And it does say in there, other approved. So that doesn't even have to be in there,
Okay.
but we can.
If it could
Madam
be,
Chair,
thank you.
Madam Chair, did you address the effective date?
Did we address the effective date?
You know, I had suggested that the effective date be, I said, a year out, if not, or 6 months. And I think you made a comment, you could support 6 months so that everybody could be apprised of the law and comport with it. If there's any potential education that's needed vis-a-vis the state code of ethics versus the other code of ethics that apply to professions in the state.
I would be okay with going 6 months out. I would not be okay with going a year out.
Okay, so it's not in the draft that I received.
No, it isn't. And I don't know how other committee members feel about that. This isn't my decision.
Seems unnecessary.
I'm not sure why. I mean, we can, your code is already in place. Your
Right.
professional code is already in place.
Right, I'm not, VSEA represents a number of other licensed professions. We've spent a lot of time on attorneys and judges, but I hate to proceed without giving those other professions a chance to mull through the impact of this vis-a-vis their own code of conduct. It's a 6 month, I think it's just a way to ensure people are fully informed of a new code of conduct that will apply to their workplace.
Madam Chair.
Okay,
given
yes.
I'm just curious that given the speed of communication now, Vince, couldn't we make it, September 1st or October 1st?
We can have this discussion. We really need to jump to, we have Carol Dawes waiting, and she's been waiting patiently for a long time. So we really need to jump, and we pass bills all the time that are take effect upon passage or take effect on July, and people have to figure out how they're going to inform their constituents, but we can talk about that.
Thank you.
Mm-hmm. Thank you. Okay. Thank you, Amarin, for your forbearance. Okay. And you all are welcome to stay with us again. And because we know you don't have very much to do with your time. So thank you.
Thanks, Terry.
Thank you. So Tucker, we are going to switch to the Berry charter change. And Tucker, if you would, I believe you have an amendment. Would you like to? And I don't know that everybody's had a chance to see it, so maybe you can do a screen share with the amendment.
Oh, was it emailed to us? Sorry.
Yes, it was.
But I don't know if you've had a chance to see it.
I'm trying to be good and not look at emails while I'm.
I know, me too. I try not to look at emails during committee, so I'm going to ask you in this instance if you can screen share.
Good afternoon again, everyone. Tucker Anderson, Office of Legislative Counsel. Yes, I prepared, pursuant to the committee's request, an amendment to H444. And before screen sharing, I will note that there is no changed language from H444 as it was introduced. So what the amendment is doing is taking H444 as it came to the House and putting it back in, everything. None of the contents of the language has been adjusted outside of one specific reference to Title 23 in lieu of a reference to general law, which was in the bill as introduced.
And that was pretty much a technical change, right?
Yes, that was the bill made a brief stop by in House Transportation. I guess that was last year. Memory fades. And House Transportation wanted to clarify a cross-reference to general law and instead use a citation to the law that governs the setting of speed limits. And I'll highlight that once I figure out how to share the correct window, which is always a little tricky. I believe that is it. Let's see. Can we all see?
You got it. Yep.
Hey, good work.
Thank you. As a Luddite, this is always very difficult for me to adjust to new technology. So even a year and a half into Zooming, I struggle with some of the components. All right, so you have in front of you a proposed amendment that would take Section 2 of the bill as it came from the House. And again, in these charter amendments, Section 2 is always the substantive amendments to the charter. We amended the entire chapter that the charter is kept in Section 2. So it swaps it out for all of the contents of the bill as introduced. To bring you back to what that contains. First, an amendment to section 104 describing the general corporate powers of the city, which adds a subsection D stating that the city shall fly only the city, state, US, and POW MIA flags. Second, an amendment to the ordinance authority contained in section 105 of the charter that states that notwithstanding any contrary provision of 23 VSA section 1007, which you were just working on in S181, that the city can adopt and enforce ordinances establishing a speed limit of less than 25 miles per hour on city streets. There are some technical corrections and replacements in the next few changes. First, in section 111, the elimination of a reference to the first constable and the insertion of a reference to the finance director within the city's charter provision requiring the bonding of certain city officials. So taking out reference to first constable, adding the finance director as a bonded city official. Second, eliminating a reference to the first constable in the list of elected officers in the city. Finally, repealing and removing references to the constable in the article of the city charter governing constables, and finally, in the section that describes the duties of the constable within the city. The other sections of the bill, first, section 1, that explains the approval of the charter amendment and the date that it was approved by the voters. And finally, the effective date, which is on passage, are not changed by the amendment. This only changes section 2, which is the substantive portions, and it brings it back to H 444 as introduced.
So thank you. If we had passed 181 last year, oh no, they passed this in 2019, so it wouldn't have made a difference, but they wouldn't have had, there were two sections in here they wouldn't have had to put in here. One was the speed limits and the other was the constable. But anyway, that's just an observation on what we're doing on the other bill.
Right.
So this amendment is being, the amendment, which is to go back to the original as was introduced, is coming from me. I asked Tucker to prepare it, given the conversation that we had the other day. And I have talked to all three Washington County senators. I will leave Anthony to speak for himself, but the other two have supported this by that this is what the voters voted on, and they feel that it is not our job to second guess what the voters voted on. Yes, but I will leave Anthony to speak for himself, and then Senator Collmore.
Well,
Go ahead,
you said it pretty well already, Madam Chair. I mean, I think if we were to not put this back in, we would essentially be negating an election that was held in the city of Barry. It was around a question, not a person. But I think we would be overturning the will of the voters, and I think that that's something that we don't like to see happening, particularly when we are concerned about what's happening to our democracy now. I mean, I think if we could say, I would say to anybody who asked, I don't like this amendment. I wish I would not have voted for it.
Yeah.
if I lived in it, if I was a Barry voter, I would have voted against it. I don't like it, but the fact is that this is what the voters chose to do, and it's not it's not up to me to overturn what the voters of Barry, City of Barry, decided to do.
Senator Collmore.
Thank you, Madam Chair. From what I remember, you also checked with the, is it 2 House members or were there more than 2?
There are 2. Peter
And they were
Anthony
okay.
Also, and they support, okay.
They were okay with it. I don't think they support the amendment. I mean, I don't think they support the provision, but they do support if we choose to put it back in. I will say that I had a few really, as you can expect, emails from people saying this was the doings of one counselor. And and that put it in, that proposed it and put it on the agenda and put it on the vote. And one, I think Barry has 3 counselors or 5. I'm not sure.
I think it's, how many, Carol?
5.
5. So one counselor could not do something like this without the vote of the other 4. So this was not the doings of one counselor. And we know that in legislation, just because one person makes a proposal, it takes the committee of 4 or the Senate of 30 to approve it. I can't do anything on my own, nor can one city councilor. So Senator Clarkson?
Carol, what was the city council's vote on it?
908 to
The city council, the city.
Oh,
You're about 5 seconds ahead of me. I was headed for the minutes to look that up.
Thank you, because what was it?
I believe it was unanimous to approve this whole set of charter amendments, but let me just.
But I believe there was much discussion about the insertion of this flag piece.
Yes, there was. The council devoted much of the month of October of 2020 to public comment around the flags, which then led to the suggestion, and Madam Chair is correct. It was one counselor who made the suggestion to put the proposed language into the charter changes, but the batch of charter changes, it was approved by the counselors, all counselors, which is 6 counselors and the mayor, unanimously to place all charter changes on the ballot.
And they were separate charter votes, as I recall, too, Carol. Is that right?
Yep.
Okay.
Each one was voted separately, and this one was approved 62 to 38%.
Alice, Senator Clarkson?
Yeah, it's just hard. The story behind this vote is not pretty, no matter how you look at it. But the vote is, I would agree. I think I also am not fond of this choice, and I'm particularly not fond of it because it sounds like the other place where people could express support for something else is not necessarily open to them, because we found out the lampposts where there are banners where other things could be flown are owned by the city, and that is incorporated in this, because this does not say
Flagpole, yeah.
I believe, Carol, and correct me if I'm wrong, but I believe it does just say flags here, but I believe it's city property. The language on it is city property. Is that correct, Tucker and Carol? If we allow this to happen, it means all city property, they couldn't fly other flags. Is that correct?
Tucker?
That's really bothering me that we limit it. Okay. Tucker, could you answer that, or Carol? Yeah.
You've gotten to the right spot in the legal analysis, but the reason it's the right spot is that the restriction here is on the city as an entity, the city's flying of a particular flag. So it's the action. If the city is flying a flag on its property, it has to be one of those enumerated flags. They can't fly any others. So that's why you get to the point where if the lampposts or whatever they are city property where the city is flying flags, it has to be one of those enumerated flags and no others. That's the prohibition.
Thank you. So that's the thing that's, I think, a little hard here, is that this limits this so fully, unless the city of Barry has again, clearly contentious conversation about banners. So banners may be different from flags, and they may have this conversation about that. But at the moment, the thing that's bothering me is that this limits that other expression opportunity.
I think that that's something that the town attorneys are going to have to figure out with what it means that the city can't fly. Because does it mean that the city can't allow the Chamber of Commerce to fly flags that say shop downtown Barry? But
during Gay Pride Month, fly the Gay Pride flag. I mean,
well, yeah, I don't care what it is. I'm just saying that I think that's something that okay, Senator Ram Hinsdale.
Well, I guess to this point, I think it does matter what it is. I would hate to see the city say it's okay to do Chamber of Commerce, shop downtown flags, but still not allow a pride flag to be flown. And I think it gets us down a very concerning path of what the city can or can't approve on city property. So I still think there are too many questions, and
well, they're going to have to approve if they can fly some banners. They're still going to have to approve what those banners are. They're going to have the conversation about which banners they want to do. And that's a conversation that they're going to have. The question is, can they allow anybody, including the Chamber of Commerce, to fly flags that say shop local? If the attorney says that this covers banners, flags, and everything, then they can't fly any of those. If they said that banners are not included, then the city council is still going to have to have the conversation about which flags and which banners they can fly. We're not telling them which banners or flags.
I mean, if we're the last stop for this bill and it's already, it may go to a conference committee. I don't know. I doubt it from what you said. But if we're essentially the last stop, then I think we should hear that from their city attorney before taking a vote.
We can hear that from their city attorney. I can tell you that it is not going to make any difference to me because they voted on it, and we can say, but the voters didn't know what they were doing, but that's no excuse. Oftentimes voters don't know what they're doing, and yet they elect us. So I think that for me, it doesn't make any difference whether they say you can fly banners or not. And that's going to mean no banners. It means that they also can't fly shop local or celebrate Barry so anyway, to me, it doesn't make any difference. Senator Collmore.
Thank you, Madam Chair. This is an H bill though, so this will go back to the other body, I believe.
It will.
Because we've amended it.
Mm-hmm.
But they'll decide whether or not to go to conference just to pass it.
I guess.
That's their decision. Senator Polina?
Well, I was just going to say, I think that when it comes down to putting this into practice, I think you might see people of Barry beginning to wonder why they took this vote, why they supported it. And because when it does come to be Christmas time or whatever, or Gay Rights Week, whatever it might be, and people are going to be told they can't put their flags or banners up, I think they'll be coming back to the city council and saying, we made a mistake here. We need to change this back.
So if I can say something here, Senator Clarkson, you look like a Michael Dion, some kind of a Reformation painting here with the sun shining in. It looks like you have your kind of sainthood.
Right. An aura.
Yeah, anyway.
It will be brief, but it's a lovely moment.
So I don't know how other people feel about this. We can hear from the city councilor. It isn't going to make one bit of difference to me, because the voters voted and it said city can fly. And if the voters didn't know what they were voting for, that's the responsibility of the people of Barry.
I would like to hear from a city councilor. I'm just hearing, I don't want to say Carol is giving us any misinformation, but I'm hearing there may have been some informal votes or pre-votes to that final vote that were divided. So I really think we'd be doing our due diligence if we talk to a city councilor as well, not saying anything about you, Carol, but I would like to double check about what the vote looked like and how people felt about this.
You mean how the city councilors felt?
Mm-hmm.
It was unanimous.
It was
unanimous. I'm getting other information that there may have been some other divided votes before a unanimous vote on the entire set of charter changes.
That might be, but I don't know that
like there were.
I don't think that that's, if we had a bill in judiciary and at the beginning, 2 people were in favor and 3 people were against, and then we started talking back and forth, and then 4 people were for and 1 was against. Does that have any impact on the fact that the bill came out of committee on a 5-0 vote? I don't think so, because I think that it is the final vote that makes the difference. I don't think we can start delving into the.
Well, I think given that it was taken out of the House and we're putting this specific provision back in, I would like to know how the city councilors felt about this specific provision, because that feels like the question at hand. Should we put this provision back in after the House took it out?
Okay, I'm going to suggest that regardless of how the city councilors felt, the population voted for it overwhelmingly. And that should be our concern, not how the city councilors felt, because we could pass a bill out of this committee and the Senate would vote it down.
Right.
But that doesn't mean that it was a wrong vote. We supported something and they didn't. And that's the final vote. I don't think that the question here in my mind is, do we honor the vote of the people or do we not? And that's, in my mind, that's the only question that there is. I'm not taking any position on the value of it, whether it was right or wrong, whether they knew what they were doing, whether they didn't know what they were doing, whether the city council fought with each other or bribed each other. That isn't my concern. My concern is, do we honor what the voters voted for? That's all. And I think that we do that.
I'm just asking for more information and I don't see the rush.
I wish you had asked for that when we put this on the agenda before.
I had thought we were getting a concrete answer about flags in other places that are city owned.
Well, would that make a difference?
I would like to hear from the attorney Barry about how they would interpret that. Yes. So, and while we're at it, I think we should hear from a city councilor about what the vote was and the impetus for this change.
So, and should we hear from all 4 of them, or the one that proposed it, or the one that, okay, Senator Clarkson.
I reached out to a city councilor and had a long conversation, which is, a back and forth about it. I guess part of me would also just like to know if a flag is a banner, Tucker, or a just because to me, that's the challenge, is just shutting down so much. It's one thing to shut it down for the few flagpoles we're talking about at the fire station and at the city hall and some other places. But if it's shutting down an entire city of expression, that's a harder thing for me. I don't know why, but it is. Tucker, is there a difference between a flag and a banner, or should we not? Is this really moot?
I'm going to try to be very un-Tucker-like and keep this as straightforward as possible. Flag is an undefined term here. There are plenty of examples that I could point you to where specific legal requirements are set out for what constitutes a specific flag. The United States flag, there are tons of examples where measurements are involved, the way that it's flown is involved. Here, there is no legal backup or definition that I can give you for what would constitute a flag. Full stop and pause, because the important piece here for what the city is going to have to consider if they are going to attempt to circumvent the restriction in some way to say, this is a flag versus this is a banner, is that this is closing a qualified public forum, which we discussed last time with the Sons of Confederate Veterans case in Virginia, right? The argument that the Sons of the Confederate Veterans brought forward was this was a traditional public forum, flags could fly there. We should be able to use our speech rights and fly the Confederate flag when we have our parades. And the analysis was the closure is for everyone of access to the qualified public forum. That is the legal analysis that the city is going to have to go through. If the decision is made to fly banners because they're not flags, then the necessary question is going to be, are they opening that qualified public forum for specific people, but not others, and using the flag definition or term as the basis for making that decision and drawing the boundary between who gets to raise a banner versus who gets to raise a flag. Because if it's just the material, the size, and the location of that speech forum, then that speech forum immediately becomes open and must be governed by a fair procedure. So again, if it's open to, for example, the Chamber of Commerce or the other entities that you brought up, is it open for proposals for other groups to say, well, we have a banner or a pennant that is not a flag, it is this other material, this other thing, and we want to put it on the city lampposts. And you get back to the discussion that the city has been having around flags.
Got it.
Well, I was going to propose that we vote on this today. Because I think a lot of this discussion goes beyond what we can do or not do. We have a charter in front of us that represents the vote of the city of Barry from their last, well, I don't know how long ago this was voted on, but a town meeting
In
of some.
2019.
All right. So.
Oh, no,
almost
no.
3 years.
Last year.
Oh,
20.
last year, 20.
So
21.
at last year's town meeting, this was the vote. And I don't know, well, I don't know what else to say. I think this discussion is good, but I don't think, regardless of what answers we might get from one of the city councilors or the lawyer for the city, I don't think that has any bearing on whether we vote for this amendment or not.
Well, it has a bearing for me, and I have information that the initial vote to include this in the charter was 4-3, and to get the charter changes to the voters was potentially 5-2. So I just think, to me, it's very important to have this information. And I think it represents us doing due diligence on the change that voters are making, that which they may not realize they have made.
Okay, I'm going to say this, and then I'm just going to be quiet, because I'm going to vote for this amendment regardless of what we hear from them. Because first of all, I don't think we should be judging whether the voters knew what they were voting for or not. That is up to the people that live in Barry to figure out if people knew what they were voting for. We could do that on every single vote that happens. Did they really know what they were voting for? We could, when we're getting the Burlington charter change, did they know what they were voting for when they included every single rental in their?
A lot of those issues were vetted in the House. This provision was taken in the House, and we're putting it back in, and it has not been thereby vetted. There was no debate on this on the floor. This has not been vetted.
We're a separate body, and we do not have to do what the House does. That's why we have two branches here. We are supposed to do ours. I don't think we have the right to determine whether the voters knew what they were doing or not. And I also do not think we have the right to try and figure out the machinations that happened before the city council had their final vote, because those are the workings of government, and we've seen it in many of our committees here in the Senate, that votes, people change their votes. People decide, no, I don't like that. Yes, I do like that. And so I don't think we have the right to try to figure out how the city council got to a unanimous vote. That's not our concern. So we can put this off another 2 weeks.
Or we can
but
have a vote. I think you've got the votes to pass it.
The city of Barrie would really like to get this approved so that they can do their speed limits and get rid of their constable. I mean, their constable wants to leave. They're not getting rid of the constable, but they would like to make that official. So
this probably makes me a no vote on this bill and the bill about municipal charters, unfortunately, because I think it's really scary to pass this one and know that other communities could potentially start to have these votes about removing flags all over the state.
Carol?
I just wanted to say a quick look back at the minutes of the council meetings during this period of discussion shows the votes that Senator Rahm Hinsdale are referring to, but they're associated with a flag policy, not with placing this language on the charter. The whole thing ultimately rolled into the drafting of the charter proposed language, which was ultimately unanimously agreed to by the council to place it on the banner, on the ballot.
So Carol, Carol, so there's a flag policy independent of this charter change.
Correct.
So that's already in place.
Correct.
So why do they need, I mean, well, okay, they decided to. So is the flag policy parallel, mimic this charter change?
No.
So the flag policy is different. So which trumps which? The charter change will then trump the policy.
That's my understanding of law.
Okay, that confuses it even more. Okay. I think you, yeah.
Sorry.
I just don't think we're doing our due diligence. I just want to say that before the vote.
Well, I haven't proposed that we vote. I was going to.
Maybe.
You know, I just would be very leery of hearing from one or two city councilors. If we were going to hear from them, I would want to hear from all 5 of them and the mayor. And if we were going to try to determine whether people knew what they were voting for, I would want to make sure that we polled all 1,300 people or whatever it was that voted, because I don't know that they didn't know what they were voting for. And as Anthony said, they might wake up tomorrow morning or whenever, if this passes and gets signed, they might wake up and say, oh my gosh, what did we do? And do another charter change. And they can do that in March or at a special town meeting. They can't do it this March because it's too late to get it on the warning, but they could do it on a special town meeting in May.
And Senator Rahm Hinsdale, I'll just say this. I appreciate your position. I was in a similar position, as you well know, with some of the charters that we took up this session and ultimately passed, even though I voted no on them. And I think that's pretty much all we can do, is have a committee vote, send it to the floor, and see what happens on the floor. And you're certainly welcome, obviously, to vote no on whether we should take it up or not, and vote again no on the floor. I don't know how else to resolve it.
Yeah.
I'm happy if we take a vote today.
All right.
Okay.
I will move that we vote draft 1.1 of H444 out today favorably.
Okay.
And this is a strikeout amendment.
Senator Clarkson.
No.
Senator Collmore.
Yes.
Senator Polina.
Yes.
Myself, Senator Hinsdale, no. Senator White.
Yes.
So I would further
Okay.
move that we vote out draft 1.1 of H 444 as amended.
Senator Clarkson.
No.
Senator Collmore.
Yes.
Senator Polino.
Yes.
Senator Hinsdale, no. Senator White.
Yes.
3-2.
So, Senator Polina, do you want to report this on the floor?
Do I want to?
No, no. Will you? I will do it if you don't want to.
No, I'll do it.
Okay,
I feel
great.
like I should.
He's our Washington senator.
I know.
I'm going to make it clear that I don't like the amendment.
I'm not sure that, I don't know that any of us do. If I were, actually, I must say, I'm not sure what I would do if I were on the city council in Barrie in terms of trying to figure out which have a month's worth of discussion about which flags you can fly and which flags you can't fly and how you're going to do that, and looking at all the policies, and are you going to do religious flags, and are you going to do national flags? I would not want to be in that position as a city council member or a select board member, just because, I mean, you would have it, but it would be.
Well, it clearly, Barry, I think, already did the work of creating a flag policy. So clearly they're, I think it's incumbent on towns and villages to have criteria for these things and policies. So my guess is people will be developing them.
They might.
But we would always hope there might be a separation of church and state on town flags.
No, I don't know how you could do that.
Well, that's the Constitution. Go back to your Constitution. I mean, there is a separation of church and state.
It just says that the government can't control the religion or can't adopt a particular religion. Our Constitution says everybody should be free, but it also said every person of every sect of Christian faith ought to observe the Sabbath on the Lord's day.
Yeah, right.
That's what our Constitution says.
I hunger for a free Sunday.
So, Tucker. Okay.
So Tucker,
do you have another bill for us to vote on?
I suppose I do.
Thank you, Carol. Thank you, Carol. As always. Okay.
I believe it is posted on the committee's page. Gail, correct me if I'm wrong, but there should be a draft 1.2 of the amendment to S-181. By and large, amendments that I can cover very quickly. I removed any reference to Australian ballot from each of the provisions where the town was voting. And there was actually one that was hidden in the recall section of the bill that said the majority of the ballots cast at an annual or special meeting called for that purpose. So I removed that and replaced it with by vote or with approval of the voters at
good.
annual or special
Thank you.
meeting. As for section 3 of the bill containing the vote to suspend charter authority, first, I inserted 3 years as the period of the suspension based on what the committee asked me to do. Second, I removed any of the additional procedural requirements around the annual special meeting that would be called for this purpose. The committee had indicated that this should be parallel to ordinance adoption and that it should be, and I wrote this down, as streamlined as possible. So now this vote is just bound by the requirements for any other article that is for an annual or special meeting. So to run through the section, subsection A contains the authority to vote to suspend for 3 years specific authority granted in the municipality's charter and instead use later enacted general law, provided that the proposal is approved at an annual or special meeting warned for that purpose. Full stop. Subsection B provides that the proposal can be brought by the legislative body or by voter petition, and that the proposal shall identify and contain the later enacted general law. Boom. Subsection C says that if the proposal is approved by the majority of the voters at an annual or special meeting, no reference to Australian ballot, then the clerk shall certify the results of the vote to the House and Senate Committees on Government Operations. That was my understanding of what you had asked for, that you just wanted the notice of the results of the vote and not any of the additional documentary requirements.
I think that's right, yeah.
Removed from this section were the requirements that the official copy be kept in the clerk's office. It is my understanding that that would be the case anyway. If the town has any interest in certifying that this actually happened, it's going to be kept in the clerk's office as a public record anyway. Finally, subsection D states that annually on or before November 15th, the Office of Legislative Counsel will prepare a list of charter provisions that can be considered and reviewed for repeal by the General Assembly. And again, you have that 3-year window where this is effective. The municipalities have suspended their charter provision. They're operating under general law, and the General Assembly has an opportunity to repeal the charter provision permanently.
Great. I think you did a good job with that. Thank you.
Thank you, Tucker. I would move. I'm happy to make a motion, Madam Chair.
Okay.
I would move that we adopt that we vote favorably draft number 1.2 of S-181.
Okay.
Uh-oh, we've lost Anthony.
Nope. There he is. Okay, we have a motion.
Motion to amend and approve draft 1.2 of S-181.
Are we ready for a vote?
The only thing is it needs a new time on it. Tucker, the time cannot possibly have been 9:24 a.m.
Oh.
The date would have to be updated too. I can do that right now.
Okay. No,
Okay.
I assume you were. So I just wanted to point that out.
Yeah, I kept looking at that time and saying, goodness, is he, what was the name of the guy that
He
went backwards? Button, something?
Right.
Yeah.
Okay. So we have a motion on the table.
All right. Senator Ram Hinsdale, do you want to call the roll?
I'm just looking through it right now to see how the charter change in Barry would not be included in something like this. Flags would not be included. I'm just looking through all that with zoning and things like that. Okay. Sure.
No, you're good on this one. This is not.
Okay. I am good now. Okay. Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Polina, you're on mute.
Thank you. Yes.
Senator Ram Hinsdale, myself, yes. Senator White. I didn't hear a yes, but I don't.
Oh, I'm sorry. Yes. Yes.
Okay.
I'm sorry.
She's
that matters.
so excited that she can hardly speak. Okay.
I think you want, yeah, go ahead with your further motion.
So my further motion is that we vote out favorably, maybe enthusiastically, S-181 as amended.
Okay. Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Polina.
Yes. Yes.
Self, Senator Ram Hinsdale. Yes. Senator White.
Yes.
Passes 5-0.
Would anyone like to report this?
We wouldn't dare. We wouldn't dare. Are you kidding? This is your baby.
Well, let me just say, if I could,
Oh.
that Senator White's got a lot of babies coming up. There's
she does.
S-155. Well, perhaps I worded that incorrectly. But she's got S-155 to do, and she's got the pension left to do. So I think
I was
maybe you
thinking,
could do this one, Senator Clarkson.
I'm happy to do it, or I'm happy to let somebody else do it. I just thought of it as her baby, so I was just
You know,
thinking-
it's fine. I'm happy to have anybody else report any bills that they feel attached to. I have no, what is it called? Ownership.
pride of ownership.
Pride of ownership or sponsorship at all.
But was I wrong to assume that you would probably do the public safety one and also the pension?
I was thinking maybe you could do the pension one, but no, I'm happy to do that, I guess. 'Cause
Oh, my
as
goodness.
chair of the task force,
I think so.
I'm going to let you do the reapportionment one from the reapportionment committee.
Okay.
So, okay, so Senator Clarkson, do you want to do this one? Or should we give it to our town guy?
Well, he,
Do you want to split it?
I'm happy to do it together. I mean, it's like that would represent all these towns, you know, the state. It was certainly the middle belt of the state. I'm happy to split it. I'm happy to do it. It's just
it shouldn't take very long to report it.
No.
Yeah.
And to be fair, all of the provisions in here could have been in individual charters. It just sort of grabbed everything together. And so I don't think it'll be particularly controversial either.
Oh, I'm not worried about it.
All right, Senator Clarkson, it's yours.
Okay.
Okay.
Tucker, we're working together.
And now I only hope that we can do the ethics, the ethics bill.
It looked like in the end, what Terry suggested 2 days ago, if we had done it, we would have had it already voted.
I'm not sure.
I'm not
because
sure about that. I think they all needed to vet their their hypotheticals that were kind of like really, really nitpicky, particularly given the fact that this happens all over the country all the time.
And the fact that when it was suggested that we that we don't cover the legislative branch and the judicial branch, none of the attorneys that work for the executive branch would have been exempted anyway. I didn't get but anyway, okay. So I think that I have another meeting that I have to go to.
Yeah.
Oh, okay.
So thank you.
I will, at Tucker, I don't know, you're sending it to Gail. Who's sending it to Bloomer? Last time we had a little bit of a challenge, so.
I'm still here, so I can maybe walk it up if Tucker, although this secretary might be gone by now. It's almost 5 o'clock.
The reporter has to send it to the Senate staff.
Okay, never mind.
So Allison,
Gail
if you
Gail and Allison and Tucker can work together to figure that out.
Okay, I just have a meeting at 5 o'clock, so I'm a bit of.
We'll do it tomorrow.
It won't go on the calendar anyway tomorrow.
Okay.
Because it's past 4:30. Okay.
Okay, great.
Thank you, everybody. Thank you.
Good work.
Good conversations.
Yeah, no, I think that's one of our challenges, you know. It's a hard one, honoring. Yeah, that was hard.
Yep.
Okay.
Bye.
Bye.
So Allison, oh well.